Okay, there was a filing in Chili's case in Ohio. I know Merb has gone through this from a legal point of view. We'll miss out the preamble and get straight to the meat. So this is, his case was dismissed. Well, this is a motion for reconsideration. So let's go. Points and authorities. A. Judgment on the pleadings, fact-based analysis, including probable cause. In assessing the pleadings, we take as true all well-pleaded material allegations. The motion for judgment on the pleadings is granted when no material issue of fact exists and the party making the motion is entitled to judgment as a matter of law. There's a reference. Where this court interpreted the motion as a motion for judgment on the pleadings under Federal Rule of Civil Procedure 12C and decided that there were no material issues of fact for trial, this court made an error of law because plaintiff alleges a lack of probable cause and defendants allege the opposite. Although in the Sixth Circuit the burden of proof for lack of probable cause is on the claimant, plaintiff has consistently alleged that the defendants lacked probable cause. Where the court interpreted the motion as a motion for judgment on the pleadings under Federal Rule of Civil Procedure 12C and decided the facts, this court made errors of law by not taking as true plaintiff's allegations, by failing to find on a sufficiency of evidence, and by acting as a finder of fact without the jury, since probable cause is a fact-based analysis. Another reference. The determination of probable cause is an inherently fact-based analysis that must be conducted on a case-by-case basis. Additionally, defendants have not alleged which circumstances the police officers were reasonably aware of when plaintiff was arrested. Here, probable cause was not decided by a jury, which comprises an error of law. Probable cause is a defence from liability, not a defence from suit. Where this court interpreted the motion as a motion for judgment on the pleadings under Federal Rule of Civil Procedure 12(c), this court made an error by not putting the burden of showing that there are no genuine issues of material fact on the moving party, the defendants. The moving party has a burden of demonstrating that there is no genuine issue as to any material fact, and a judgment on the pleadings is to be entered if the evidence is such that a reasonable jury could find only for the moving party. Here the defendants fail to even allege that there is no genuine issue of material fact in their motion. The closest defendants come is alleging that they are entitled to a judgment on the pleadings if there are no material issues of fact. If defendants had established probable cause, plaintiff alleges that the trespass statute then is inherently unconstitutional because it was used to Chile is civil rights. The statute may be void for vagueness or overly broad. Alternatively, that probable cause may exist, but that officers typically exercise their discretion not to do so, and so exercise their discretion to arrest plaintiff because of retaliation. Under Rule 12C, a party cannot move for judgment on the pleadings until after the pleadings have closed. Here, no answers have been filed. Here, this court had made several errors of law and fact of dismissing the majority of plaintiffs' claims as not surviving an untimely and improbable probable cause analysis. Several errors there. B. Lower pleading standards. This court has decided in its order that Castro argues that the city defendant should have escorted him off the premises instead of arresting him, but he points to no legal authority. To state a civil rights claim under 42 U.S.C. 1983, a plaintiff must set forth facts that, when construed favourably, establish 1. The deprivation of a right secured by the Constitution or laws of the United States, 2. Caused by a person acting under colour of state law. Plaintiff is only required to plead the facts, not make legal conclusions. Plaintiff did plead and did include video evidence of him entering a traditionally public forum, shouldn't that be traditional, to exercise his First Amendment rights, and that he was denied a permit and arrested as a result, and that this is a policy of the policing organisation, either due to a written policy or failure to train. Plaintiff further alleges, based on information and belief, that his arrest was retaliatory for his exercising his rights, and that evidence of retaliation will be available through discovery. specifically that the trespass enforcement is not content neutral. Moreover, plaintiffs' rights were chilled if the actions of the defendants would chilly a person of ordinary firmness, regardless of whether they actually chilled. Beside the claims raised, plaintiff has likely also stated facts sufficient for claims of fabrication of evidence, supervisor liability, failure to intervene, conspiracy and abuse of power by a jailer, among others. Here, defendants ostensibly arrested plaintiff for violating Ohio's criminal trespass law. However, if instead, as plaintiff appears to allege, defendants arrested him because of the contents of his speech, then defendants acted in violation of the First Amendment in ways that should have been clear to a reasonable officer. This court cited, absent a showing that officers arrested an individual without probable cause, a retaliatory arrest claim fails. These cases are distinguished by the fact that they are summary judgment motions where a showing of evidence is appropriate. Requiring a showing of evidence at this stage in the pleading is inappropriate. Here, this court made an error when applying pleading standards to the First Amended complaint. See trespass. The court has ruled that plaintiff was, by his own admission, in violation of Ohio criminal trespassing statute when he chose to remain in the building after it closed without privilege to do so. This is false and is not supported by the pleadings. To the contrary, the First Amended complaint states at approximately 5 p.m. a City of Arlington employee announced that the building was going to be closed and locked. DeCastro was not given time to leave the building. Plaintiff had privilege when he entered, and he did not lose privilege because 1. The building was not closed to the public, and 2. He had been ordered to leave by someone with the authority to revoke his privilege. Although plaintiff did not have his privilege revoked, plaintiff continued to protest for the privilege to remain beyond the normal closing hours to exercise his First Amendment rights. At no time was plaintiff denied that privilege. Regardless of usual business hours or posted business hours, a person has a privilege to enter an establishment when it is open to the public and an unlocked door during business hour continues to extend a tacit invitation to the public. Here, plaintiff's privilege was not revoked simply from some unknown person telling him that the building was going to be closed, which also by definition indicates a time in the future. By the wording of ORC 2911.21 (a) 1 statute, including the word knowingly, it is clear that the intent of the statute is to require intent. Here, plaintiff did not allege intent, but the opposite. Defendants further failed to allege intent. Neither plaintiff or defendants have alleged that any of the defendants had the authority to revoke plaintiff's privilege in City Hall. Defendants' failure to allege authority is the grounds for an adverse inference. This court must interpret the statute to be constitutional, even if that interpretation departs from the most natural reading. Here, this court failed to interpret the Ohio trespass statute so that it does not violate plaintiff's constitutional rights. Plaintiff made a lawful entry of the City Hall. Plaintiff's privilege was not revoked, specifically by anyone that was authorised to do so. The City Hall was still open to the public when plaintiff was arrested. Members of the public remained inside and the doors remained unlocked. The court has made numerous legal errors in deciding otherwise. D. Search of plaintiff's phone. This court found that plaintiff only made a conclusory allegation of his phone being searched. This is false and not supported by the pleadings. In the First Amended complaint and opposition, plaintiff states facts sufficient to show why has knowledge and belief based on the SIM card and tray missing and that the area of insert was damaged. Additionally, the attempt to get a search warrant is an indication of intent, and the fact that his phone wasn't immediately available shows that the defendants wished to maintain it as evidence. Further, defendants do not deny having searched the phone, which is grounds for an adverse inference, and discovery will provide additional evidence on or admission. E. State remedies for damaged phone. This court found that plaintiff does not allege that the state remedies available to him were inadequate. This is false and not supported by the pleadings. Plaintiff stated that the results of the state's replevin action as being Wagner stated that she had no idea what happened to the phone. Further, that plaintiff was not afforded an opportunity to report any damages. Opposition. It is clear that the state procedure did not remedy the constitutional violation. Additionally, which this court cites, is distinguishable in that it was for illegal seizure of property and not illegal search. Additionally, the defendants in their individual capacities do not represent the state. The court also finds that no evidence was presented as to any damages, citing the defendant's allegations in its motion. This was false when the defendant said it, and it is false when the court said it. Here the court made errors of fact. F. Leave to amend. When a motion to dismiss a complaint is granted, courts typically permit the losing party leave to amend. Plaintiff requested leave to amend prior to dismissal at opposition. A district court should normally grant a pro se plaintiff leave to amend, where the plaintiff could possibly cure the pleading defects by pleading additional facts, even where the plaintiff has not requested leave to amend. Generally, if it is at all possible that the party against whom the dismissal is directed can correct the defect in the pleading or state a claim for relief, the court should dismiss with leave to amend. A district court's failure to grant leave to amend a complaint will be reviewed for an abuse of discretion. G. Excusable error by plaintiff. The court will consider documents filed after the complaint as part of the pleadings. Here, plaintiff has submitted facts in later documents. In general, plaintiff lays out the facts for all of his claims and presents sufficient facts to raise non-frivolous issues in his filings. Plaintiff expected to be able to amend his complaint at least a second time, preferably after discovery had been completed. Errors of law or fact errors of procedure or evidence, mistake or inadvertence or surprise caused plaintiff to leave out allegations in his first amended complaint. Conclusion. Plaintiff respectfully requests for defendant's motion to be denied and for leave to amend his first amended complaint. And whilst I'm doing lawsuits, I thought we'd have a quick look at the lawsuit that official misconduct for public safety's girlfriend has filed in Indiana. So it's a complaint and demand for jury trial. Comes now plaintiff Tiffany Napier as pro se litigant in this matter and respectfully files this complaint and demand for jury trial and would show the following. 1. That the plaintiff Tiffany Napier is a resident of Harrison County, Indiana, and who, at all times relevant, has conducted business in Scott County, Indiana. 2. That the defendant, William K. Meadows, is a resident of Scott County, Indiana, who, at all times relevant, has conducted business in Scott County. 3. Mr. Meadows has willfully, knowingly, maliciously, and intentionally inflicted emotional distress upon the Ms. Napier without just cause and with the intent of harming the plaintiff, and as a direct or proximate cause of Mr. Meadows' actions, the plaintiff was in fact irreparably harmed by the defendant. Shouldn't that be irreparably? Oh well. On to page 2. 4. Mr. Meadows has intentionally, maliciously, and without just cause slandered Miss Napier's name, YouTube channel, and reputation in the community by making knowingly false, malicious, and intentional statements about the plaintiff's criminal record, previous involvement with the Department of Child Services, and the outcome of those events, current lawsuit in the Southern District of Indiana, YouTube channel, official misconduct, the plaintiff's boyfriend, Christopher Reiter, and his YouTube channel for public safety. Ms. Napier is part of, as a direct or proximate cause of Mr. Meadows' actions. Ms. Napier was in fact irreparably harmed by the defendant. 5. Mr. Meadows has intentionally, maliciously, and without just cause or consent, unlawfully shared unredacted copies of the Department of Child Services confidential documents regarding reports that had been made into DCS and documents regarding the Chin's court case and private information with YouTube channels that published the information Mr. Meadows gave them on live stream videos on YouTube and currently posted publicly visible videos and community posts, and as a direct or proximate cause of Mr. Meadows' actions, Ms. Napier was in fact irreparably harmed by the defendant. I wish such long paragraphs there. I mean, I suppose you can interpret them, but 6. Mr. Meadows intentionally, maliciously and without just cause appeared on several live stream YouTube videos, and as a direct or proximate cause of Mr. Meadows' actions, Ms. Napier continues to suffer irreparable harm. 7. YouTube channels by the names of Frauditor Troll, Aztec Ninja Frauditor, Fraudit Wrangler and KFAR continue to create and broadcast new videos about Ms. Napier and Mr. Writer, and refuse to retract their live streams and publicly viewable videos after asked to take them down immediately after publishing them on approximately the 6th and 7th of August, and plaintiff and Mr. Writer have continued to request these YouTube channels to take down these videos and stop creating more. The channel owner of Frauditor Troll may have possibly complied with Ms. Napier and Mr. Writer's request to take down published videos, but still needs to be named for the purpose of this complaint. Yeah, but you're not complaining about those channels. I don't get it. 8. Ms. Napier and Mr. Writer both filed for a protective order at the Scott County, Indiana Courthouse on the 9th of August with case number of 72D01-2308-PO-000201 for Mr. Writer and 72D01-2308-PO-000200 for Ms. Napier, and are currently awaiting a new judge to get assigned to it so a decision can be made. 9. Mr. Meadows, with the help of his wife, Mrs. Meadows, have been intentionally, maliciously, and without just cause making knowingly false, malicious, and intentional statements about the plaintiff since 2018 and Mr. Writer since 2019, and continue to do so after Mr. Writer sent at least 2 cease and desist notices to them via messenger, which confirms the message was received, as well as the plaintiff and Mr. Writer notifying local law enforcement of the damaging and threatening behaviour of Mr. Meadows and his wife, Mrs. Meadows. 10. Plaintiff has attached a copy of another cease and desist that was sent to Mr. Meadows and Mrs. Meadows via first-class mail prior to this complaint being filed with this court. 11. Plaintiff and Mr. Writer have sent another cease and desist request to all above-mentioned YouTube channel owners via email, as well as contacting the YouTube legal department for their assistance with delivering them as well. 12. Plaintiff and Mr. Writer intend to take further legal action against the above-mentioned YouTube channels and their owners that have failed to take down their published videos, live streams, and community posts that are about or pertaining to Ms. Napier and or Mr. Writer and the YouTube channels for public safety and or official misconduct. Wherefore, Ms. Napier prays that this court grant all appropriate relief and will issue a temporary injunction against Mr. Meadows and all the YouTube channel owners of the above-mentioned YouTube channel names, preventing them from continuing to harm the plaintiff in the manner set out above, and that the plaintiff has no other remedy in law and will be harmed further should said injunction is not issued. And that was submitted on August the 14th. It's weird because only one defendant is mentioned, but they're requesting the judge order against third-party YouTube channels who are not part of the lawsuit. It's a weird one to me. Anyhow, that's dumb waiter for you. And I don't know if you noticed, but I did, that although it's his girlfriend lawsuit, he seems to have inserted himself into that lawsuit. It's mentioned many times, but his protection order request is not relevant to this lawsuit. His YouTube channel, he isn't the person suing in this lawsuit, so any damage to his YouTube channel or his reputation is not covered by this lawsuit. So I don't know why he's in there. Why is there so much about him? Maybe because he's a bully, he's a big head, he's stupid, and official misconduct is dumb that she allows him to bully her around and insert himself in everything that she does. Anyhow, thanks for watching.